respectfully recognize the presence of Chief Mrs. Folake Solanke, who is present with us this evening. This is actually the capping of the whole exercise we've been having since the beginning of this conference. And what we are doing is setting a framework for public interest lawyering in Nigeria. Now, lawyering in public interest would require a lot of sacrifices. And I believe, for one, that first, you must take law practice as a business and as a calling that will put food on your table before you start chasing after cases that you do just in the interest of the public. So we are looking at setting the agenda, capacity building for public interest lawyering, and then looking at the activities of the just constituted Public Interest Litigation Committee of the NBA. I have been informed by the chairman of SPIDEL, my boss, that we have just 30 minutes to wrap this up. And I would implore everybody to keep strictly with time. The major speakers will have 7 minutes each to speak to their papers. We do not want somebody reading from page to us. And thereafter, we have 3 minutes for each of the discussants to throw light on what we are doing here. So I call on Mr. Tobenna Erojikwe to give us his position.
Good evening, Mr. President, Mama, delegates. I stand on existing protocol. I was going to deliver a 30-minute paper, but we have 7 minutes. So I'm going to compress it as much as possible. I was asked to talk on capacity building and enhancement of practice skills on public interest lawyering, a continuing professional development perspective. I understand that we are all hungry and ready to go, but it would be good at least to keep quiet and hear what we have to say. So the topic is actually an interesting one because it raises 2 fundamental issues around the situation of our country, Nigeria. One is on capacity. That is the ability to do the things that we hold ourselves out able to do. And this is particularly significant for lawyers because, of course, we have a duty of care to our clients, and indeed, we must carry out our activities and our work at the highest level with the highest level of professionalism. So it's a problem that we have across the board everywhere in Nigeria, and so it is something that we must talk about even as lawyers all the time. And the second one is the public interest. And I think it's the failing and the failure of society that we no longer ask about what is right and what is wrong. And there is no better profession or no better placed profession to ask those questions than the legal profession in Nigeria. So we at the Institute of Continuing Legal Education are excited about the opportunity to actually work with SPIDEL in advancing and developing curricula that would actually encourage and deepen the body of public interest lawyering. Now, one of the interesting things about public interest lawyering is that if you try to carry out a research on public interest lawyering, you'll find that there is no consensus on what it means. So it actually differs from jurisdiction to jurisdiction. But you find that behind it is the social issues that each environment and each country has. So for instance, the issues you have in America or China or in Brazil are different from the ones that you have in Nigeria. But at least there is some sort of consensus about what our issues in Nigeria are. And because we are gradually moving to what is called a failed state, I think that it is very, very critical and important that we pay more attention as lawyers to public interest lawyering. And indeed, I posit that that every lawyer in Nigeria is a public interest lawyer, because every day we engage with authorities and organizations that exhibit crass impunity and disrespect for the rights of people. And it's indeed that element that we think that SPIDEL and all Nigerian lawyers should rise up to. And so from a continuing development perspective, how does one approach the resolution of these issues and actually train and equip lawyers generally to be more active in this area of endeavor? I mean, many scholars have said that in defining public interest, some have tried to define it using the representation. So who do you represent? Others have tried to define it using costs. But because public interest differs from one person to the other, sometimes it is based on the political leaning. But at the end of the day, in a country like Nigeria, where the issues are almost obvious, it's important that at least we challenge them. And so how do we intend to carry out the trainings that we talk about? We look at them from two perspectives. One is philosophical and jurisprudential. That is, how do we create a consciousness amongst our people through training? How do we create a consciousness amongst lawyers through training around those substantive elements of law that we were taught in school that were fundamental indeed to our becoming lawyers, that might not be as profitable as some of the practices that we do or we carry out, but are indeed fundamental to lawyering itself. And so, taught courses like constitutional law, jurisprudence, administrative law, based around contemporary issues that border on Nigeria, are things that the continuing professional development committees of the various sections, and indeed the ICLE, intend to focus on going forward. Then the second bit of it is actually the skills that are required. So how do you go about the issues? I mean, I think today in Nigeria, when you talk about public interest lawyering, the focus is actually on public interest litigation, going to court all the time. And we've had many successes. I mean, very successful public interest litigation lawyers like Ganifa Wemi, Dr. Abakaba, and the rest of them. But we are looking at a situation where we actually equip and train our lawyers with basic skills that teaches them about where to go, how to approach these issues using quasi-judicial bodies and the judiciary itself. And then also deploying things like those basic principles of administrative law that we were taught in school, judicial review, and others. So that is basically our focus on this. I had ended the paper by saying that it is my hope that this afternoon's conversation will establish that all that I have said in this paper does not make sense, and that a better perspective is introduced to the search for enhancement of practice skills in public interest lawyering. I hope that I have made sense at all in the little time that I have, and I thank you for the opportunity of having addressed you. Thank you very much.